Hello, and welcome to another edition of Coffee Talk with Immigration Attorney Brian D. Lerner. We are talking in this set of videos about USCIS Manila and the various procedures and items they can take and so forth. They will take waiver applications, so if you have been found to be inadmissible to the United States for some reason or another and need to do a waiver of inadmissibility, it is possible to file it at the USCIS field office in Manila. Now, persons who have been found to be ineligible for admission to the U.S. can file at this particular office under Form I-601, which is the application for waiver of grounds of inadmissibility. Now, keep in mind that you can also apply here for a permission to reapply for admission into the U.S. That would be under Form 212. Now, just keep in mind that the form numbers are just the tops of the whole petition. If you decide just to fill out the form and send it in, not a chance it's going to be approved. There needs to be declarations, affidavits, evidence, and when my firm does it, returning cover letter, and so forth. Now, basically, there are restrictions to applying at the field office in Manila. Basically, if you reside in the Philippines and have been found inadmissible by a consular officer at the U.S. consulate in Manila, then you have the option of filing Form I-601 and Form I-212 at this particular office. Now, in person, you can actually file in person at window 25 on the second floor of the U.S. Embassy, new annex building, 1201 Rojas Boulevard, Avenida, Manila, Philippines, daily between the hours of 8 a.m. and 12 noon. So you can just walk in there and hand it to them, assuming you paid the fees. Now, if you reside in any other country within USCIS's Manila jurisdiction, you must file Forms I-601 and or 212 with the consular section of the U.S. Embassy or consulate where you applied for your immigrant visa. After the consular section will forward your waiver to the Manila field office. Okay. Now there are times, everybody wants to get back into the U.S., but there are times where you want to make an I-601 expedited adjudication request. So the question is, how do you do that, and under what basis will they accept it? Well, applicants for waiver of inadmissibility under Form I-601 may request that the USCIS office expedite adjudication of the I-601 waiver application where there are extraordinary circumstances that are time-sensitive, compelling, and necessitate the applicant's presence in the United States that would be sooner than would be possible if it were processed under normal times. Now, a strong desire to immigrate to the U.S. as soon as possible, of course, is not an extraordinary circumstance. The expedite request must be made in writing and delivered to the USCIS field office director. The applicant must provide evidence of the extraordinary and compelling circumstances. This means lots of documents and letters and so forth. And the USCIS office will notify the applicant within 15 days of receipt of the request if it is granted. So if no response is received within 15 days, then you must presume that the request has been denied. Now, you need to be aware that approval to expedite the adjudication of the I-601 does not guarantee approval of the waiver application itself. It just means that under the circumstances, they've agreed to expedite the adjudication of it. By the same token, if the expedite request is denied, it doesn't translate into a denial of the waiver either. Okay, more on the coming videos.